Welcome to the Family Law Frontline.
Welcome back to the Family Law Frontline with Fedor Kozlov. Fedor is the founding partner and chief litigator at the Law Office of Fedor Kozlov, PC. With over a decade of experience in Illinois family law, he handles high-stakes cases involving custody, property division, domestic violence, and complex divorces. I'm LeAnn Lyon, and today we're talking about temporary custody orders in Illinois and what happens before a final judgment is entered. Hello, Fedor.
Hello, LeAnn.
Great to see you again.
Great to see you too.
And Fedor, when a custody case is first filed, when do temporary parenting orders usually come into play, and what purpose do they serve before a final judgment?
Well, when a divorce is filed, and obviously when you have when parties have kids, usually uh, a bunch of motions also filed, and one of them should be a motion for temporary custody
Mm.
or Illinois. It's no longer custody; it's allocation judgment, judgment for decision making and visitation plan, pretty much. So usually it's filed right away, and the reason it's filed right away because it's the time of the most uncertainty between the people. The kids are always confused, of course, what's going on, and we need a court order on a temporary basis to tell husband and wife or father and mother how to go about handling children, who is responsible doing what.
Okay. What issues then at that point are typically addressed in a temporary custody order?
Usually it's we always look at the history of this family. That's always everything that we need to do when the children are involved has to be done in the best interest of the children. So what's in the best interest of the children is what the history shows us, a history of this specific family. So if it's a mother, most of the time it's a mother who would spend time with children, bring them to school, do the homeworks, things like that, then obviously, children, we don't want children to feel this change. They're going to feel it anyways, because I'm sure they love both parents, but we don't want them, to take them from the house where they used to, would grow up, would have their friends, and the parent who would take care of them now all of a sudden, it's not the same way. So we want to maintain the status quo for the children. So that's why we look back, and it doesn't matter if we have a newborn, if we have a teenager, or if we have somebody in high school. We look back and see what was the history, what was the immediate history, who was the primary caretaker for this specific child.
Since these decisions happen early, what information does the court rely on when there hasn't been a full discovery or testimony yet?
So with children, it gets tricky. Um, we spoke a lot about our past podcasts about child representatives and guardian ad litems, but in general, like I said before, with all due respect to these people who's doing wonderful job on behalf of children, jails and child representatives, uh, I always suggest to my clients that you want to see if you can make a decision, amicable decisions with your partner or your husband, your wife about children, because children are always vulnerable when it comes to divorces. And now you have a stranger in the life who makes decisions for them. So as far as the discovery goes, you can discover how much money people spend and what was their income. But as far as discovery in terms of uh, children, it's kind of it's a difficult question, and you always know, usually up front, even from your own if you have a father as a client, they usually come forward and say, yeah, I'm busy at work all the time, so my wife will take care of the children all the time. Or if you have vice versa mother who's taking care of children and she's your client, she's going to tell that.
Can you walk us through a case where a temporary custody order ended up influencing the direction of not only the temporary case, but the entire case?
So usually it's pretty much each and every case when the temporary decision comes, then goes into permanent. The Sometimes uh, a party, usually it's a husband, would be a husband or a father, who would say, I want a 50-50 custody. Well, first of all, there's no such a thing as 50-50 custody, uh, because you cannot just, 50-50, 60-40. I don't like it when people trying to use numbers when in reference to children. It has to be done in the best interest of the child. You cannot just take a child from another person because it's a 50% custody time came up. So usually people use it for the purposes of paying child support or paying less child support, because we have a formula that heavily depends on the amount of nights that a child spends with each parent, and that's how we calculate. One of the huge factors, that's how child support is calculated. So when potential client is trying to do that, I might even decline the case, because I don't think that it would be fair to a child. First of all, reduce child support, because remember, child support is for the benefit of the children. It's not about husband and wife, father and mother. It's for the benefit of a child, and you trying to reduce the payment of support for your own child. So I think it's unfair. And secondly, if you never saw a child before as much, which is okay when the family, there has to be somebody who goes to work and someone who takes care of children at home or school. But then all of a sudden you want to be 50% custodial parent, and you probably cannot even do that. And remember, custody, when we talk about custody, temporary or permanent, has to be with the parent. So you cannot just leave the child with your mom, grandmother for your child, and go about your own business. It has to be time with you. So if you cannot afford it, if you cannot spend that much time, you should not go for it. You should not claim it.
That's interesting. So, what kinds of evidence tend to carry the most weight at this stage, especially when the court is still working with limited facts?
The testimony of the parents, usually that's the main evidence, and it's very easy. You asked me before to walk through the case. I do remember one case that kind of stands in my head, when a father again wanted to spend more time with the child than he used to, and he was claiming 50-50 from the beginning, and he was upset that he would not get that 50-50. During the deposition, he was asked multiple questions as to, the names of the teachers that your child is going to school. He was not able to answer that question. Then he was asked, if he knows the kid's grades. When was the last time when he went to his soccer practice? Or when was the last time that he went to a performance of his child at school? Or medical records, being able to take your child, for regular checkups before school, especially for medical records. If the child needs braces or eye exam, things like that. And when a parent is not aware of things like that, it means a lot to the judge that this particular parent pays no attention to the child. Maybe he does. I should not say that. He probably did, but again, not as deep as the mother. So for him to claim 50% um, custody of the child, simply not fair.
How often do temporary arrangements end up becoming the framework really for the final custody order, even if maybe that wasn't the original intent?
I would say 90% of the time, 9 out of 10. Again, the temporary, when you start the divorce, you don't know how the loan is going to go, for how long, and how divorce is going to end.
Mhm.
Um, and Once you have a child, if you have a child, and there's a child custody issue, we have to have a temporary order. And the reason is, again, it's for the benefit of the child, because let's say that, I don't know, one of the parents, again, the father shows up and says, "This is my time," and the mom disagrees, or a child, you know, child has his own life, his kids and friends, and he has plans. So she has plans to go to someone's birthday, and now the father shows up and says it's my time. So that's why we need to have this temporary custody, or kind of keep everything status quo, and not so it doesn't go outside of it. So everybody knows what to do, and everybody behaves in the best interests of this particular child. And then if the status quo is kept, in a very rare circumstances, and that actually happens to mothers. Mothers, like in my experience, make decisions without consulting with fathers. So I said, fathers usually don't spend too much time with children, and they are the ones that claim children try to claim 50% of the custody in order not to pay child support. Not all of them, but a lot. Mothers tend to make decisions themselves, and that's kind of disturbing, and that is something that the court will not like, because there's still a biological parent out there, and he has a right to know that the child was, goes to this private school instead of public school, or that the child has glasses now because his vision went bad, or that sometimes mothers simply go to a different state without notifying the father that they plan on doing so. That's an extreme case when the father can take the custody back when the mother does something like that.
Wow. Have you seen situations where one parent pushed for a specific temporary schedule as part of a broader litigation strategy?
Yes, the answer is yes. And again, it could be a strategy, it could be a point of pressure on the other side. It might be sanctionable under the Illinois Supreme Court Rule 137 for the lawyers. If a lawyer knows about it, he should not encourage. The lawyer should discourage and advocate the client not to do so, and tell the client that it has to be in the best interest of the child. But it happens. You don't really know sometimes how it happened, what are the decisions behind these things. And it's also interesting how it happens sometimes in practice. So we had a client that was pushing for these particular visitations for schedule for a long period of time. He kept saying that this is because of his work. We kept telling him that the work is secondary, the child is prime, that's prime concern, and it has to be in the best interest of the child, not his work schedule. But as soon as the judgment was entered, he stopped exercising his visitation rights. So it tells a lot that, how much he cares about the child. Again, the child visitations is a right; it's not an obligation. That's unfortunate for the mothers, because they you can it's a right of a biological parent to spend the time with the child, but it's not an obligation. So sometimes we have cases when it's called post judgment, when the judgment is already entered and the child is waiting for the father, usually for the father to arrive, and the mom has plans of her own, and the father never arrives, never comes pick up the child. That's very upsetting.
Very upsetting. What missteps during the temporary phase can hurt a parent's position later when the court is deciding on that final custody decision?
I have a case right now, and I'm not the first lawyer who came into that case. And that case been going for, I think, 7 years now. And it's all about children, one particular child. And the missteps, if we talk about it, that unfortunately was done by the mother, who's uh, who we work with. But the problem with the missteps is usually when um, decisions are made without a proper notice. I would say that everything that has to do with children or a child has to have some kind of notice. And that's why we have applications specifically designed for the parents to talk to each other. I understand that sometimes emotions takes place and people cannot stand each other, cannot talk to each other, they hate each other sometimes. But that's why we have these apps. There's one called our Family Wizard, and the other one is Talking Parents. So far, I know only about two apps. And the courts and the judges encourage people to use them. They cost minimal amount of money, but these are the apps where you discuss children, you discuss parenting time, you discuss everything that's in connection with the children. You don't have to call somebody if you don't want to. You don't have to text anybody. Sometimes people even have orders of protection against each other. The orders of protection can exclude communications about children through those apps, and they always admissible in court. So if you, and again, the life happens. That's what we also tell our clients. We're not robots. We cannot just live by a court order. So you can be in traffic, or can be running late, or the child might have a stomach flu, and you don't have to, if somebody's else visitation time and child have a stomach flu, you don't have to bring the child to the other parent. You can just send him or her a notice saying, hey, this is what happens, and that's all. When people don't do that, those missteps bring to more and more litigation and increased cost uh, for a particular case, because others file a bunch of motions and things like that.
Well, just briefly as we wrap up today's episode, for somebody preparing for a temporary custody hearing, how should they approach it so that they're thinking beyond the short term order?
If you preparing for a hearing or court appearance for the temporary custody, um, you probably just need to be ready uh, to talk about your job schedule, because the work schedule is number one of the first considerations taken by the court. If you have a child, you need to let the court know that you will have flexibility and mobility to spend time with kids. After COVID, a lot of people work from home, so that's a huge plus that you should mention to the judge, because if you can work from home, that means that you can always bring the child from school, do the homework, prepare lunch, and things like that. If you're on the road, if you're a driver, a long distance truck driver, then it'll be a little bit more harder for you to do. But what I tell clients, if you can talk to your employer and, let's say, change your schedule, and I gave you an example with truck drivers, like instead of long distance, be a local driver and be home every day at 5, something like that. That will be taken into consideration and be given a huge plus to you, because you're showing out to the court that the child is in the first place for you, and you're going to change your work for the benefit of this child.
Beautiful. Well, that is it for today's episode of the Family Law Frontline. If you are facing a custody dispute and want to understand how temporary orders could shape your case, visit lawyer-il.com to connect with Fedor Kozlov and his team. Thank you for listening, and remember to like, subscribe, and leave a review if you found this episode helpful. Thank you, Fedor.
Thank you.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.